Okay. Hello and welcome to the 2021 Lions Cup round of 16s. Please ensure that you are muted unless you are submitting. Judges may keep themselves unmuted throughout the round. I will be giving time signals. 3 minutes when you are at the 7-minute mark, 1 minute at the 9-minute mark, and then time at the 10-minute mark. At the 10-minute mark, I will also verbally say time. Again, please note that no additional time will be granted for day 2 rounds. Please ensure your phone and computer notifications are turned silent. As a reminder to mooters, do not inform the judges of the schools you represent. Your team number and full names are sufficient. Judges are not permitted to ask or to be notified of school affiliations. Also, a reminder that no feedback will be given after rounds are over. Competitors are to return to the main room where the winners of the round will be announced. Please note that I may take photos of the round for social media purposes authorized by the 2021 Lions Club Steering Committee. Unless there are any questions for me, whenever the judges are ready, we may begin.
Thank you, Ms. Sangha. I believe we're starting with the appellants with Ms. Trang.
Yes, thank you. Before I begin, I would just like to confirm if my sound and positioning of the camera is acceptable to the court.
Yes, thanks.
Yeah. And I would also like to know who is serving as Chief.
I believe I'm serving as Chief Justice today.
Okay, thank you. Good morning, Chief Justice and honorable members of the court. My name is Trang, initial J, and I'm accompanied by my co-counsel, Aladina, initial S. Before I begin, I would like to first acknowledge and give respect to the land on which I present today, the territory of the Mississaugas of the Credit First Nations. We rise on behalf of the appellant, Her Majesty the Queen, in the case at bar. Would your justices require a brief summary of the facts?
That's okay, counsel. You can proceed with your submissions. Thank you.
Okay, thank you. The appellant requests that the Supreme Court of Lions Cup allow the appeal, dismiss the lower court's ruling, and answer the test question in the negative. The appellant has 3 submissions to make before the court today. Our first submission is that a member of an Aboriginal collective located outside of Canada does not qualify as Aboriginal Peoples of Canada under Section 35(1) of the Constitution Act 1982. Our second submission is that Mr. Desautel cannot establish continuity as per the Vanderbilt test. And our third submission is that there's a real threat to Canadian sovereignty if the constitutional protections of Section 35(1) are extended to include Aboriginal groups located outside of Canada, as well as the appellant's proposed remedy in the case at bar. I will be addressing the first submission today, and my co-counsel will address the last 2. Members of the court, this case is about reconciling the relationship between Aboriginal and non-Aboriginal Canadians who have lived and participated together as full and equal members of Canadian society. This is not about any other Aboriginal groups who are located outside of our borders. As agreed upon at the Supreme Court of Canada level, to determine whether Mr. Desautel has established the continuity element of the Vanderbilt test, it is first necessary to answer the threshold question: whether or not an Aboriginal group whose members are neither Canadian citizens nor residents can fall within the meaning of Aboriginal Peoples of Canada under Section 35(1) of the Constitution Act of 1982. We are in agreement with the lower courts that have established Section 35(1) must be interpreted in a purposive manner, but it must be done with the proper context of Section 35(1) in mind and not extend the meaning beyond its intended purpose. We submit that upon a purposive interpretation of Section 35(1), the words Aboriginal Peoples of Canada may only include the modern-day successors of Indigenous groups that currently located in Canada, not members who are not and have never been residents or citizens of Canada. As this court has previously acknowledged in the Queen and Powley, Section 35(1) rights may only be exercised by virtue of an individual's ancestrally based connection in the present community. Any other interpretation would be inconsistent with this previous finding at the Supreme Court of Canada. This will be—
Counsel, I'm going to have to stop you there. Quote here, you had mentioned full and equal. How in this scenario these groups are being treated full and equal, because from my understanding, We're talking about a tribe here that was forcibly removed from their ancestral land. And then since then has been completely deterred and oppressed and not able to come back and actually exercise their rights. So I'm not really sure what you mean there with how things are being treated full and equal. If you could please elaborate on that.
Yes. Justice, we respectfully acknowledge that with colonization, the displacement of Aboriginals to other countries did happen, but we submit that today that with colonization also came international borders and sovereignty of our nation, and we must respect that today we have things such as citizenship and residency. And we submit that with the Constitution Act of Section 35(1), we must impose this citizenship or residency requirement upon the Aboriginal peoples of Canada.
Well, yeah, but isn't the problem that the concept of citizenship and residency is a colonial concept in and of itself, and is one that's arguably foreign to the Aboriginal peoples who were here prior to European contact. So arguably the reason that Mr. Desautel wouldn't be able to make his claim out today in your submission is simply because the Crown came in and in one way or another forced him and his predecessors, his ancestors, to move away from the land.
Justice, as the trial judge noted, while they were not, the Snipes tribe was not forced out at gunpoint. And so when we look at the Crown,
Counsel, is it the appellant's position that simply not being out at gunpoint is enough? Is that sufficient? Because I'm pretty sure that just because they weren't at gunpoint, it doesn't mean that they weren't forced out. And it doesn't mean that in all these past years, they haven't been deterred and essentially blocked from exercising these rights. So I'm not sure that that is sufficient enough for me. And I'm also not sure that the citizenship requirement really makes sense either, because as my co-justice did point out, again, they were pushed out of these lands. It's not as if they didn't want to be a part of it. And it's not as if citizenship is exactly a practice that is totally common there either. So I'm not sure if there's any other way you can rectify it, or if you can explain why the citizenship part really is so important.
Yes, certainly, Justice. We submit that, yes, while they were not, might not have been a voluntary move, our friends will likely submit that the creation of the Oregon Boundary Treaty will be the reason as to why the Snipes tribe was forced out of Canada. But we submit that even with the creation of the Oregon Boundary Treaty and the 1896 Game Protection Amendment Act, even with the outlaw of hunting, they were still able to come back. They still came back into Canada and continued this practice. So we submit that if it was so integral, they would have continued coming back even after this outlaw and the boundary treaty.
But would you not agree that the fact that there is an international border and that they don't have the ability to come to Canada as of right, unlike somebody who lives in Canada, in fact makes it all that more difficult for them to even have been able to exercise this right?
Sorry, Justice, would you be able to rephrase your question?
I guess I'm still sort of caught up on this border issue. The fact that there's a border is an impediment to their ability to exercise their rights, and has been for over 100 years now, since the Oregon Boundary Treaty came into effect. So I'm wondering why, but for that treaty, but for the boundary, arguably the Mr. Desautel and his ancestors would have continued to be able to exercise that right. So I'm wondering, why are we drawing this arbitrary distinction between who is currently situated north of the border and who is currently situated south of the border?
Justice, we submit that we must impose the citizenship or residency requirement because this is what the lower courts have noted, for instance, when doing a purposive interpretation of Section 35(1), such as in Beckman and Little Salmon, Cormac's First Nation, the grand purpose was defined as reconciliation, but only in a mutually respectful long-term relationship between Aboriginal and non-Aboriginal Canadians. So when we look at the drafting history of Section 35(1), it is relevant to look at the source of the minutes of proceedings, for instance, as this include Aboriginal representatives who all shared the same understanding that Section 35(1) and the Constitution for Aboriginal Rights is only meant to protect those that currently reside in Canada. For instance, one of the representatives for the Inuit Committee on National Issues, Mary Simon, stated that upon a proposed Aboriginal rights and freedom provision, that it could only be providing for Canada's 3 groups of Indigenous peoples, which she could only be referring to our present day groups, the Indian, Inuit, and the Métis. And while we understand that those involved in the discussion are not representatives of all Indigenous groups, it is still important to take into account the drafting history of this legislation, because when they use in Canada and Canadian synonymously with of Canada. Honorable Justice of the Court, it is clear that Section 35(1) of the Constitution Act of 1982 was never meant to include Aboriginal peoples located outside of Canada who are neither Canadian citizens nor residents. We cannot broaden the constitutional protections of Section 35(1) to Indigenous peoples located outside of our borders. And for these reasons, we ask that the Supreme Court of Lions Cup allow the appeal, dismiss the lower court's ruling, and answer the test question in the negative. Barring any further questions, my co-counsel will now address the last 2 submissions.
Thank you, Ms. Trang.
Okay, thank you.
Counsel, whenever you're ready.
Thank you. Justices, before I begin with my submissions, I would just like to apologize. I'm not sure if you've been informed, but I do have an accessibility accommodation, so I won't be standing up today. And I would also just like to confirm that my camera and my audio are all okay.
Yes, Counsel, thank you.
Thank you. Good morning, honorable justices of the court. My name is Alidina, initial S, and I rise to conclude submissions on behalf of the appellant, Her Majesty the Queen, in the case at bar. Before I begin, I would like to first acknowledge and give respect to the lands in which I present today, including the territories of the Wendat, the Anishinaabe nations, and the Haudenosaunee Confederacy. The appellant's second submission is that Mr. Desautel cannot establish continuity as per the Vanderpeet analysis. And our third and final submission is that there are very real and significant threats to Canada's sovereignty by extending the constitutional protections of 35(1) to include Aboriginal groups located outside of Canada. And that the appellant's proposed remedy is to enter a verdict of guilty on both counts, contrary to the Wildlife Act, and remit the matter to the trial court for sentencing. Justices, it is the appellant's position that the Vanderpeet test for an Aboriginal right under Section 35(1) is not satisfied in this case, because the trial judge committed a reviewable error in her application of the Vanderpeet analysis, finding that the continuity requirement was met. While the appellant does concede that an unbroken chain of continuity is not required, we do submit that the flexibility of the interpretation of continuity has its limits. And in the case at bar, the limitation that has been crossed is one of a lack of evidence. The only evidence offered at trial about the Lakes tribe's presence in British Columbia at all before 2010 was a singular event in November 1972.
So counsel, just to clarify, so if you can see that you don't need an unbroken chain to have continuity, and that your concern really is a lack of evidence, let's say hypothetically someone from the tribe came over once a year, let's say it was one person. In your submission, would that have been enough to continue continuity and then this wouldn't be a problem?
Yes, Justice, our submission is that if there was, my apologies, if continuity had been established and the evidence was direct and much stronger, that perhaps Mr. Desautel could have satisfied the Vanderpeet analysis.
Thank you.
Furthermore, the only evidence that the Lakes tribe maintained a connection to the claimed right was the fact that the land was not forgotten in the minds of the Lakes tribe members, and that the Lakes tribe engaged in the practice of hunting in Washington state at the time of contact. Not only is this an incredibly low evidentiary standard to set, but the evidence presented about hunting in Washington state is inconclusive in the case at bar. Now, as my co-counsel has submitted, our friends will likely present the fact that the creation of the international border and the outlawing of hunting through the Game Protection Amendment Act of 1896 explains why the Lakes tribe had gradually ceased hunting. However, the trial judge did hold that the Sinixt had continued to hunt in British Columbia up until the 1930s, despite this legislation.
Counsel, I just have a clarification question so I can understand your submission. Is the issue that is your position vis-a-vis continuity that that there was insufficient, or sorry, was it that too much time had elapsed between the last time that the right was sufficiently exercised, or was it that the evidence presented at trial to prove continuity was insufficient?
Our submission is that continuity is not established because there is not sufficient and direct evidence.
Okay, so the temporal aspect, whether it's 60 years, 7 years, 80 years, between instances of the exercise of this right is not relevant?
The temporal gap is relevant for the reason that the Lakes Tribe's absence for the province for a period of almost 30 years cannot be explained from 1982, when existing Aboriginal rights were elevated to constitution.
Well, arguably an explanation is the fact that there's an international border.
There is an international border. However, the Sinixt continued to hunt despite the international border in 1846 up until the 1930s. Our submission is that we cannot establish continuity because they stopped hunting, even though they did it when it was outlawed in 1846. Quite simply, Justices, there is no direct evidence between 1930 and 2010 that the Lakes engaged in anything.
Counsel, I'm not completely sure that I'm suffice with that answer. I just feel like since they did stop, there is plenty of reasons or other explanations other than just the border why they might not want to go there. I mean, again, let's look at Mr. Desautel right now, an example of what happened when someone did try to exercise this right, or at least when they got caught doing it and there was evidence of it. So I'm not sure that that answer is sitting perfectly with me. And the temporal gap is still something that I'm not really understanding, because while yes, they may not have been on this land for the last 30 years, it's my understanding that one, they continued this practice while they were still in Washington. So yes, they weren't doing it in BC, but this is still a practice that they do hold dear with them. And two, they had this land for years and years and years before the last 30. So would that time even prior not be enough? And would the fact that Mr. Desautel himself, and I'm sure many others, have wanted to or have even tried since then, like does that not make up or compensate for the last 30 years?
Justice, the appellant's submission is that a single shot cannot create the Lakes Tribe's modern exercise of the right. And in the absence of even minimally cogent evidence, this conclusion is inescapable. While the Vanderpeet approach does not operate to amplify the cogency of evidence adduced in support of an Aboriginal claim, we must place due weight on the Aboriginal perspective and ensure it's supporting evidence in equal footing with more familiar forms of evidence. And these phrases means exactly what they suggest: equal and due treatment.
Counsel, I have a sort of a broader question, sort of around the policy implications of the decision that this court will be making based on your submission. And that's in the spirit of reconciliation, bearing in mind that one of the purposes of reconciliation is to reconcile the relationship between the Crown and the Indigenous peoples who lived on this land prior to European contact. And given that Mr. Desautel has ancestors who belong to those groups who were here prior to European contact, is your position not incompatible with that policy goal of reconciling this relationship?
The appellant's submission is that Mr. Desautel is not an Aboriginal person of Canada. And for that reason, we cannot give him Section 35(1) rights, because if an Aboriginal group located outside of Canada is entitled to exercise 35(1) rights in Canada, then they must have equal protection under the Constitution and be able to exercise and access a full panoply of rights in the same fashion as Aboriginal rights holders within Canada. And nothing less would uphold the honor of the Crown and further Canada's ongoing process of reconciliation with its First Peoples. However, reconciliation must be all or nothing. And the appellant's position is that we should be focusing on reconciling with the Indigenous peoples, the Aboriginal peoples of Canada, who live and feel the full burden of our laws today. Furthermore, if I may continue, extending the constitutional protection of Section 35(1) to include Aboriginal groups located outside of Canada leads to concerning outcomes that it would set on an obligation to invite representatives of these groups to constitutional conferences. The appellant's position is that this is contrary to the organizing constitutional principle of democracy and is inconsistent with the purpose of patriation to allow Aboriginal peoples located outside of Canada in Canada to participate in Canadian democracy as required by 35(1). Furthermore, a multitude of challenges would arise with respect to the Crown's duty to consult. The number of groups to consult and, where appropriate, accommodate would dramatically increase. And the appellant's position is that accommodating the interests of 35(1) rights holders outside of Canada would run counter to accommodating the interests of 35(1) rights holders within Canada. Honorable Justices, it is the appellant's position that while we cannot deny the importance and protections of our nation's borders, for that reason, to side with the respondent's position would be to turn a blind eye to the fact that Canada is a sovereign nation, and that we must look after and protect those who live, work, and feel the full burden of our law. My colleague has elaborated why Mr. Desautel is not an Aboriginal person of Canada, and the consequences of not following this position stretch far and wide. Barring any further questions, the appellant rests.
Thank you, counsel. We'll now hear from the respondents, Mr. Abtan.
Thank you, Your Honor. And before I begin, I would just like to confirm that my camera and audio are acceptable.
Yes, thank you.
Thank you. I would also like to acknowledge that we are on the traditional territory of many nations, including the Mississauga of the Credit, the Anishinaabek, the Chippewas, the Haudenosaunee, and the Wendat people, and is now home to many diverse First Nations, Inuit, and Métis people. Good morning. My name is Abtan, first initial S. With me is my co-counsel, Samus, first initial D, and we rise to represent the respondent, Mr. Richard Lee Desautel, in the case at bar. It is the respondent's position that the Supreme Court of Canada correctly ruled upon the respondent's claims. And in support of this position, the respondent has two submissions to make before this court today. The first submission is that Section 35, subsection 1 of the Constitution Act protects Aboriginal people located outside of Canada. And the second and final submission is that Mr. Desautel can claim the constitutional protections of Section 35, subsection 1 pursuant to the test established in the 1996 Supreme Court of Canada decision of Georgina and Vanderpeet. I will be addressing the first submission, and my co-counsel will be addressing the latter. Based on the totality of these remarks, we respectfully request this honorable court dismiss this appeal with cause. Your Honors, this case is truly about defending our Aboriginal people from further oppression at the hands of Canadian law, and more specifically, from preventing members of Aboriginal tribes that were exiled from their homeland from being denied rights based on the sole fact they no longer live there. Section 35, subsection 1 of the Constitution.
Counsel, sorry, if someone isn't a citizen of Canada, why should they be afforded rights in Canada? Don't they have an American citizenship? Can't they exercise their rights there?
Respectfully, Your Honor, just because an individual in an Aboriginal tribe is not a citizen of Canada does not mean they don't have the right to the land within Canada. As I have done in the beginning of my submission, we are on Aboriginal land. This is not Canadian land, and we must recognize that this land belongs to the people who have been here first.
So on that point then, counsel, because this is something that's a sticking point for me, if Mr. Desautel is not a citizen of Canada or a resident of Canada, he doesn't have mobility rights under Section 6 of the Charter to enter Canada. He's not able to enter Canada as of right. So as far as the implications of this decision go, if we were to grant a citizen of the United States the ability to exercise an Aboriginal right under Section 35, but we weren't to grant him mobility rights under Section 6 to enter the country, how would he even be able to exercise these rights in the future when there's no guarantee that he would be allowed to enter the country?
Thank you for your question, Your Honor. And to touch on that point, mobility rights are, while not considered in this case, very important, and I appreciate you bringing that up. as the case for mobility rights can be one that is solved within the legislature. However, setting a precedent that these rights for Aboriginal people cannot be exercised within Canada, therefore eliminates the reconciliation purpose, as I will continue to explain, of Section 35, subsection 1. And therefore, if this determination was to be made, it would be misinterpreting the true purpose of Section 35, subsection 1.
Right, but we can't just look at Section 35 in a vacuum, right, and ignore the implications that it would have for vis-a-vis other rights. So I'm still struggling. How would we even ensure, and how would the Crown ensure that its honor is upheld in allowing future Aboriginal rights claimants, future individuals who want to cross the border to exercise their rights, if they won't even have a right to enter the country?
Yes, Your Honor, and to confirm your question, you are asking that if we rule upon this case that Aboriginals outside of Canada do have rights within Canada, then how do we justify the mobility right of Section 6?
Well, how it seems incompatible to me to say, yes, you have a Section 35 right, you're able to come into Canada and hunt and shoot deer or whatever it might be, but you don't have the right to actually enter Canada under Section 6 because you're not a citizen. Those seem at odds with each other.
Yes, Your Honor, and I would argue that, therefore, in determining the true principle of the honor of the Crown and the Crown's relationship of sovereignty over Aboriginal people, that then Section 6 of Section 6 mobility rights should then be awarded to Aboriginal people coming into Canada.
Thank you.
Thank you, Your Honor. To outline why exactly
Counsel, sorry, I think I want to follow up on my co-justice's question here, which is similar but not exactly the same. Okay, so let's give mobility rights to these people. My next question is going to be more about the floodgates. So once we open this, we're setting precedent for a whole bunch of different people and a whole bunch of different groups to come over and make land claims in Canada. Now, yeah, there's a lot of groups we know about, including this one in the United States, which would definitely be included, but there are so many Aboriginal groups from all over the world and from so many different places. We're not really sure the full capacity for what we're actually going to be opening up to. So how is this then supposed to be controlled? Are we going to have a complete backlogged system with hundreds of thousands of people trying to make land claims to come over here? Because if we do it on a case-by-case basis, that seems to be the outcome. How else is it supposed to be controlled to not have that situation happen?
Yes, Your Honor, and respectfully, there are 2 points to be made on your question. Firstly, the floodgates argument that any and every Aboriginal individual can make a right claim within Canada cannot stand, as there are several criteria that are identified that must be fulfilled in order for an individual to exercise an Aboriginal right within Canada. Therefore, it could not be any and every Aboriginal individual, whether that be in America or in another country, but those who have a tie to the land and who qualify under the Vanderpeet test. Additionally, to touch on your point about how it would backlog the system and it would create a huge conflict, I would argue, or the respondent would argue, that it is important to note that the true purpose of Section 35, subsection 1 is both recognition and reconciliation. And in recognizing and reconciling with the majority of Aboriginal tribes that have been oppressed by Canada and forced out of their country, this would fit with the purpose. And whether that may be a long and tiring process, it is still one that must be taken to achieve this purpose.
So counsel, then, sorry, go ahead, Chief Justice.
Sorry. I was just going to say, so you're basically proposing a 2-tier system whereby the mobility rights would essentially be at the expense of the Canadian citizens, right? Of the Canadian citizens that are already in these lands, right? So it's one thing to say that Aboriginals have Canadian ties, that their claims should be considered, but when my brother Justice talks about not being a citizen, and my sister Justice talks about floodgates, right? You want to create a 2-tier system whereby these claims should be considered no matter what, at whatever expense of the government, no matter how unrealistic that may be logistically, and basically say that those non-Canadian citizens could have a right at the expense of Canadian citizens. So it's one thing to say for Aboriginals of Canada, but like really what you're asking the court to do is to overrule the entire like legislative system to protect Canadian citizens, right? So like how far do we go to do that for people that are claiming rights outside of the country?
Yes, Your Honor. And to touch on that, it's important to note that these people who are outside of the country in this current era are only outside of this country because of the Crown's assertion of sovereignty over them. And as such, it is the Crown's role.
Well, for how long can you say that for, right? How long have they been living in other countries that you can say, oh well, they haven't come back for 40 years, and they bought a house and they're living very nicely in another country. Oh, but they're not coming back because we forced them out. Like, how long does that argument really last?
And on that point, counsel, wouldn't the solution be to engage in negotiations between cabinet and members of these nations to allow them for easier border crossings? This happens all the time with border communities. Why do we have to go through the courts, and why are you asking this court to make this decision?
Yes, Your Honor, and I notice I really have 30 seconds left, so I will briefly answer your question and then quickly conclude. Just to touch on that point, you are arguing that since it has been 40 years, which is quite a long time, it would be unjust to determine that they can just have access to Canada at any given time. But when looking at the large timeline of the history of Aboriginal people within this nation and this territory, 40 years is actually quite a short amount of time, especially for the continuation, which my colleague will touch to. And I notice I'm out of time, so barring any further questions, this concludes the first submissions.
Thank you, counsel. Ms. Tsamis, whenever you're ready.
Before I begin, I would just like to confirm that my audio and visual are acceptable for the judges today.
Yes, counsel, thank you.
Thank you, Chief Justice and honorable members of this court. My name is Tsamis, initial D, and I am here on behalf of the respondent, Mr. Richard Lee Desautel, in the case at bar. The respondent's second and final submission is that Mr. Desautel can claim the constitutional protections of Section 35, subsection 1, pursuant to the test established in the 1996 Supreme Court Canada decision of Regina and Vanderpeet. The test is conducted as follows. First, it must be determined whether the evidence in light of the pleadings received does establish the right. Second, it must be determined whether the claimant has proven a relevant pre-contact practice and custom existed and was integral to the part of the distinctive culture of that pre-contact society. And finally, it must be determined whether the claimed modern right is demonstrably connected to and is reasonably seen as a continuation of the pre-contact practice. In Mr. Desautel's case, as was noted earlier by my friends, the main thing that must be established is the continuity element. To point to the trial judge's findings, she did find that at the time of pre-contact, this practice was integral to the distinctive culture of the Sinaiks, which is the predecessor group of the Arrow Lakes Band, which Mr. Desautel is a member of.
Counsel, it may have been very important at the time, but for the last however many years, they've been continuing their own practices in Washington. They've had their own lives there, and there's been no attempt to even come across the border. How would you reconcile that?
Your Honor, I would first start off by recognizing that although there has been a current lapse of the chain, there is no need for an unbroken chain of continuity, as mentioned in Vanderpeet, which was bolstered by statements even from the dissent, who noted as sorry, Justice, you may continue if you do have a question for me.
Sorry, go ahead first.
Thank you. Even Chief Justice McLaughlin, as she was then, noted that the unbroken chain of continuity is not required, and she was dissenting in the case of Vanderpeet. And as
okay, so I'm going to ask my question. If an unbroken chain isn't needed, where is the limit Okay, so let's say it's not 30 years. Okay, when is that point going to go? Because I don't think it's acceptable to push this off years and years and years, to have someone who is so removed, generations and generations and generations behind, who they never went, their parents never went, their grandparents never went, just to say that it was their ancestors. So if it's not 30 years, would it be 40 years? Would it be 50 years? Would it be 60 years? Is there a time that you can give me where the respondent would concede that maybe it would be too long?
And counsel, just to add to my sister Justice's question, I think that the prevailing issue, right, is how long are you going to hold unknown claims over the country's head, right? So how fair is it to continue to have the government be obligated and be responsible for an infinite amount of unknown claims without some kind of threshold time for continuity? Because really the point that continuity doesn't matter, or that the point that there can be a break in continuity, all that is to say is then you're basically putting it on the court to determine what a reasonable time based on the facts is. And so we can easily go back and say, well, 40 years, a generation's worth of not exercising that right is sufficient to say there was a break in continuity.
Yes, Your Honors. And while the break in continuity existed from 1930, there are 3 points that I would like to touch on very briefly. Despite the erection of the Oregon border, as pointed out by my colleagues, and the BC Wildlife Protections, at the time, the BC Game Provisions Act, which is now the Wildlife Act, which Mr. Desautel was charged under. Despite the erection of these legislations and borders, the Sinixt people continued to cross into their traditional territory, which is in British Columbia, to exercise these rights. Furthermore, under that, the second point that I would like to bring up is that Aboriginal peoples do not function in the same way that the Canadian government functions and the Canadian society functions. They do not have written laws and testimonies and logs of each time a member travels into the country, or which is now Canada, or into a different area to practice hunting. It is recorded by Canadian authorities that the last time this right was exercised was in 1930. However, we cannot be sure of this, as they practice oral traditions and oral relaying of the facts. And as such, we should give them proper deference and the flexibility under the process mentioned by my friends, which is equal and due process.
Right, but counsel, the oral traditions, I take your point about oral histories and traditions being acceptable as evidence in cases involving Aboriginal rights. And there was oral evidence presented here that the Lakes tribe held the land in their minds, or it wasn't forgotten, or something to that effect. And your friends have submitted that even if that is true, that simply isn't sufficient to establish a nexus between the Lakes tribe and what is today the land that's located in British Columbia.
Yes, Your Honors. And while they did make this submission, we would like to submit counter to that in the 1990 Supreme Court Canada decision of Regina and Sparrow, Justice Laforêt, as he was then noted in this precedent-setting case, that the phrase existing Aboriginal rights must be interpreted flexibly so as to permit their evolution. So we cannot strictly give meaning to what Aboriginal rights should be based on what Canada has defined as proper and sufficient evidence. We must give them the deference to submit their evidence in the ways that they are able.
But I guess my trouble, counsel, is there was evidence. I agree with you. There was evidence. We're not denying that evidence was presented and that it's acceptable for the court to hear that evidence. But there was no evidence that there was hunting for a period of 80 years. Zero hunting. Nobody hunted. Nobody came from Washington to hunt for a period of 80 years. They just, it was in their heart. They remember. They knew that they had a previous connection to the land. So that's where I'm stuck. Is in order to be able to demonstrate that there's a connection to the right, don't you have to show that the right was exercised, the right being the right to hunt on that land?
Yes, Your Honor. And while the right to hunt must be exercised and found, the trial court, which is usually given deference in Aboriginal proceedings, did find that the break in continuity was sufficient to pass the Van der Peet test. And as such, the Supreme Court of Canada, the lower court, did give their finding weight. And we submit that you all here today in the Supreme Court of Lions Cup should also give this case and the trial judge's finding weight, and submit that a contextual analysis through a case-by-case basis is the proper way to approach these types of rights going forward in the future, as it might differ from different Aboriginal rights groups or individuals who might have come into the land at different times or have practiced different types of rights with different breaks in continuity.
Counsel, how do we weigh those rights that that those people need to exercise to maintain continuity, however defined, with other actions of theirs that show loyalty or allegiance to separate themselves from the state? So what I mean by that is they're effectively, it's a catch-22. They're trying to have it both ways, right? They're citizens and they're residents of the United States. And so what do we do with that? Is that not a signal to the government that they have now sort of wanting to make other ties and have been for those 80 years?
Your Honor, just to briefly touch on that, I would say, or the respondent would submit that the erection of this border created the problem of mobility rights in the first place, which was incidental to Mr. Desautel's case, as he was never denied entry. But nevertheless, it did create the distinction of Aboriginals moving within the different boundaries of the land. And as in addition to that, the Canadian government would not be mandated to search out these groups and would not be mandated to hunt them down, but rather if the case was brought to them, they would have to give it proper deference, as was given in Mr. Desautel's case. Now, I do notice that I am out of time. For these reasons, and for those submitted by my colleague, the respondent respectfully requests that this Court of Supreme Lions Cup uphold the lower court's decision. And barring any further questions, this completes the submissions on behalf of the respondent today. Thank you very much.
Thank you very much, counsel. Thank you to both the appellants and the respondents for your submissions. I believe the court will recess now for 10 minutes to deliberate.